Can I just say something about Andrea?
Guys, welcome back. Happy Monday morning. I hope everybody's had a wonderful set of holidays, whatever kind of format that looks like for y'all. And that you're looking forward to a whole new year right on the horizon. Whole new opportunity. Do the cycle one more time, yet another revolution around the sun. Well, we are about half an hour out from our ruling hearing in the case of Tyler Robinson. And so, to just recap for you guys where we're at, what we're expecting today, and also what we're not expecting today. This is all going back to the last time that we were in court a couple weeks ago when they were having hearings on a whole series of defense motions and some of the other things that were on the table. The judge kind of pushed to the side, said, I want to have an opportunity to produce a more formal ruling on this. Do some research, write it out, make sure that he's dotted all the I's and crossed all the T's. So he went ahead and reserved his ruling on those issues for this hearing today. And so those specific issues that are still on the table have to do with, first off, the redactions from the transcript from the hearing that was held back on October 24th when they closed the courtroom to talk about shackling, courtroom security measures, and basically whether for safety reasons, Mr. Robinson was going to be able to be brought into court in his civilian clothes and without shackles on. We ultimately know that that motion was granted as to civilian clothes, but denied as to shackles. But the court has said you may not, to the media, you may not photograph or film Mr. Robinson's shackles. The other thing that was left to the side to deal with in this hearing today, this ruling today, is the several groups, like two separate groups of several media organizations, collectively filed motions to intervene as limited purpose parties. And basically what they are asking the court to do is just to recognize them as having standing to participate in any motions or issues that come up relating to closures of the courtroom or other things having to do with access. There's been, honestly, like a surprising amount, to me anyway, of litigation around what seems like a fairly, I don't know, uninteresting, kind of technical sort of issue. We're going to go ahead and look through some of it while we're waiting for this hearing to get started. Because it's just a strange priority to me, given like everything that's going on in the case and the job that you have when you're faced with a death penalty prosecution, on the state side to organize your evidence and your witnesses and make sure they're prepped and make sure you've got everything and you're producing everything that you're required to produce in discovery and so forth. And on the defense side, of course, just reviewing the massive amount of information that is prepared in the course of an investigation like this, lining up your own experts, making sure they have all the information they need to be able to do their job. We do have the preliminary hearing date now. It's still a ways down the road. It's in May, but you'd just be shocked how fast that time can fly when you're doing things like trying to coordinate with your own cell site location analyst and things like that. And you need to get them the data, but it turns out you don't have the full complete data. So then you've got to coordinate with the state, and then the state's got to coordinate with the FBI, and there's a whole process that has to be gone through to get access to the information. So it can happen very, very quickly in court time. That 5 months will just fly by. But I just mentioned that because there's a lot to do. There's a lot to do right now. And so to be prioritizing this kind of battle, this technical battle over like what is the formal kind of status that the media is going to have in the context of this case, when there's really no dispute that the media gets to participate on issues of public access. Like this is not revolutionary. This is like old U.S. Supreme Court stuff. That if there's going to be closures and things like that, the public, including the media, have to be given an opportunity to be heard on it. So we got a little bit of a hint of it at the last hearing, kind of what some of the defense concerns are. And the defense is ultimately concerned that if we give them party status, at least this is what they articulated, if the media gets some kind of party status, then that means they'll get entered into the court's record keeping system as parties. And if they're entered as parties, then that means they might be able to get access to things that they're not supposed to get access to. And so in that sense, it sounds like it's largely a pragmatic, a logistical type of concern. But that definitely isn't how it's been framed by the defense in their litigation. So let's just go ahead and take a look at it while we're waiting, so you can see what I'm talking about here. Here is the original motion. So we started looking at this one last time we were streaming on this case before the last hearing. This is the motion of these several individual media organizations: New York Times, CNN, Salt Lake Tribune, Associated Press, all these people. Motion for limited intervention and request for notice of motions to close, seal, or reclassify. Now, this request for notice of motions, at least as to reclassification, this is already established in Utah rules for basically if they're going to seal off a transcript or a document and make it non-public, there's this whole process that has to be gone through. And if the media has requested notice, then they have to have a closure hearing before they can make a final order on how things are going to be classified, if they're going to be publicly available or if they're going to be private. So all of that's already contemplated in rules that have been established, and the judge has already said they've given notice, and so request to seal documents, you got to follow the rules and do that. So this is really going to these other issues that extend a little bit beyond just sealing documents, particularly closing hearings, and then also, as we're going to see, removing cameras, because the defense has hinted that they are going to be filing a comprehensive motion to remove cameras from the courtroom, and that is scheduled to be heard later down the road in January. They haven't filed the motion yet, so we haven't seen what their argument is, but we know that is on the horizon. So we started looking through this already. The media is just acknowledging, look, there's a lot of public interest in this case. We're all trying to cover it. We're media organizations. This is what we do. Court has been routinely granting requests for coverage, but unsurprisingly, both parties have attempted to chip away at those access rights almost immediately. Yes, indeed they have. We have seen it coming from both sides, from the state as well as from the defense. Although I would say at this stage, it seems like it has shifted to much more of a defense priority, a defense undertaking than the state. So we already dealt with this in the context of the motion to allow him to appear in civilian clothing and with shackles, because the state had filed a sealed response. This is before the media is involved at all. Apparently, in that sealed response, they had suggested, well, one way to deal with this is to just not have the cameras in the courtroom. And the defense then filed their reply, and we're like, yeah, that's a great idea. The media is like, yeah, we have something to say about that. So the court did protect our interests in that circumstance. The court considered the public's right to not just have access to what's happening, but also to participate in any proceeding to limit it or to take that option away. But ultimately, yes, the court should not be forced to police those critical interests alone. And so media hold a constitutional right to intervene in proceedings like this one in a limited capacity to oppose attempts to restrict public and press access. So let's just go through real quickly what they're trying to argue, what they're seeking to accomplish. press and the public have a constitutional right to access. This is like not debatable. This is not controversial. It's very crystal clear, particularly with criminal trials. Abundant case law coming from the highest court saying we have a right of access, and that includes pretrial proceedings. That includes things like jury selection, everything that is really material to the adjudication of the case or to the rights of the individual who's being accused. So just a lot of recognition. A lot of these cases, we've talked about a lot of these cases on the channel, the press enterprise cases, the Waller case, these other ones that are from Utah, I'm not so familiar with, but these things happen on parallel lines. You get a decision out of the federal courts, and then the state courts end up kind of interpreting that and applying it to other contexts to evaluate, in their specific court structure and the way that they do hearings and things like that. How does it apply in those contexts? So as the court appreciates, a time-honored right of access is rooted in the acknowledgement that open courts foster important societal values. Indeed, it enhances the quality and safeguards the integrity of the fact-finding progress, enhances basic fairness and the appearance of fairness in the proceedings, fosters public confidence in the judicial process and acceptance of its results, and acts as a check on the judiciary and allows the public to participate in government. These are all pretty important things. If you are just out doing justice behind closed doors, we got to take your word for it that that's what's actually going on. It's going to be a lot easier to trust a system that allows you to watch it work so that you can have your own opinions and just your own reaction to, I'm seeing what everybody else is seeing, and I can agree with that outcome or not, but then we can articulate our reasons for why we do or don't agree, and then that can inform whether we need to make some changes to our system. So it's all related to our ability to participate in our system of government, kind of important American value. This is very American. This is not universal. One of the things that's kind of been on my mind lately is, Russell Brand got charged with some new charges over there in the UK. And so he's got 7 charges now, I think. And there's like 6 different women involved. And the UK has extremely different rules about public access to trials, particularly trials with allegations of that type of nature. And so I'm not necessarily real convinced that we're going to see much of it, that we're going to get a whole lot of information about what is going on, what the facts are, what the evidence is, and be able to evaluate, independently, is this a fair process that's going down, or is this is this something else? So kind of wait to see how that's all going to unfold. But I don't have a lot of optimism about our ability to kind of have an independent opinion about that, because the UK system is extremely different when it comes to transparency. It's not the highest value. Courts there are kind of the, they're part of the king's authority, part of the king's justice, and so the king has a little bit more, authority to decide if anybody else gets to participate, gets to benefit in that. Very much not the American way of doing things. We run our own government and our own courts, our own systems. So we have the right to be able to pay attention to what's going on. So conversely, denying public access precludes public scrutiny, creates an impression of unfairness and secrecy, even though the proceedings may in fact be fair. Yeah, because you're basically telling me I have to trust you, bro. And we have a long tradition in this country of not being like, oh, the government says so. Well, then I guess we'll just trust that. We'll just take that at face value. So it's not like the government has ever lied to us, right? So when you do things behind closed doors, it creates, I think, a reasonable inference of why would you need to do that? Why would you need to hide it? Do you not trust us as intelligent adults to be able to make up our own minds and judge things for ourselves? So courts have concluded that press organizations have standing to intervene in criminal proceedings to vindicate these rights. The media's long recognized standing to intervene may be exercised opposing any motion or request for closure or sealing or of any proceeding or record. And so there's a district court case from the federal courts out of Utah that holds that the media has standing relating to the right of access. And although it often depends on the facts of each case, the Utah Supreme Court has long recognized media's organizations have standing to challenge closures of court proceedings. And so they, cite these series of cases where the media has been allowed to intervene. So standing is just this idea that you don't get to exercise abstract rights. You have to have some kind of skin in the game in order to kind of warrant taking up the court's time, being involved in the process. So you don't get to go into court and litigate hypothetical rights. You have to be faced with some type of actual injury. And so courts have held media is threatened with an actual injury if they're going to be excluded from a court process that they have, presumptively a right to be able to attend and cover. So because there's no question that the media enjoys a constitutional right to oppose efforts to restrict access, only one question remains: how should that right be recognized in this proceeding in order to both protect that right and ensure arguments regarding access proceed in an orderly way? So they are asking for an order with this intervener status, limited intervener status. So first off, we have this rule that deals with the documents, the closure of documents. We've already talked about that. This is pretty well established on the document side of things. So that really shouldn't be in dispute. The judge has already entered the order on that. We're going to be really more focusing on the hearing side of things and limiting access to hearings, limiting cameras, things of that nature. I could anticipate a situation where like the gag order might implicate, the defense has also indicated they want to advocate for a more comprehensive gag order. They want to shut up more people than are currently shut up by the court's order. So possibly could extend to things like that as well. So by seeking limited intervention and an order setting procedures for closure challenges, media interveners are seeking relief for an infringement that has already occurred. So we're talking now back about the October 24th hearing that was held. It was closed. Nobody got to attend. Doubled down to shield those discussions by asking that the transcript be designated as private, which it was. And what we're going to get to see out of that transcript is part of what the ruling today is going to address. So first, they want the rule to be applied with respect to documents, but then with case law to deal with any efforts to close hearings or otherwise restrict public access to this proceeding. A specific order governing attempts to restrict access would ensure that members of the media and other interested parties are permitted to participate in closure hearings to the maximum extent possible. So they want the order to do three things: recognize them as limited purpose interveners, which does give them kind of status to receive notice of certain things and to appear and participate in the limited manner that they are requesting. Requires both the state and the defendant to provide media interveners with prompt notice of any filing or other request that seeks to limit access to filings, hearings, or other aspects of this proceeding, including by providing a copy of any such filing or request. And three, directs that media interveners will be afforded the same opportunity to be heard as would traditionally be afforded an opposing party under the governing rules, including through either written opposition, oral argument, or both. So frankly, it seems to me like a fairly limited and not particularly controversial request that they are making. Pretty normal, pretty routine. We've seen it in all kinds of different high-profile cases when there are gag orders, camera issues, closed hearings, documents sealed, things like that. The media appears and they have their say. So now let's go ahead and take a look at why the defense is saying they object to that. They don't think this is appropriate. So he's responded to the request for notice already. So they're treating it as separate. We've got the request for notice process that's in the judicial rules that deals with sealing documents. That's fine. But now we're talking about something different, the proposed intervention. He says in his response, he acknowledged that the media does have a right to notice and to request leave to be heard concerning the potential sealing of a record or the closure of a hearing. But Mr. Robinson objected to the request that he be required to take steps to provide notice beyond that which is or should be provided by the court's public docketing system. In other words, he filed a whole objection basically saying, I don't want to have to add their attorneys on my email service list. Okay. I don't want to have to like type in another email address to receive service of my motions. I want them to just have to monitor the court docket to see what gets filed and then decide for themselves if there's anything they want to appear on. Well, that's not the system that is set up under the rules. So under the rules, that's going to be a dead loser. But it like, honestly, this seems like so small and petty to me. Service, you don't want to have to serve the media. It's really what they're saying. That was their objection. We don't want to have to do that. It's really not difficult. It's really not. I think the issue is they don't want the responsibility of having to try to anticipate what the media wants notice of, but it's like, it should be kind of straightforward. If you're talking about sealing something, closing access to something, then just go ahead and send it to the media. Like, there's 2 groups, 2 lawyers, 2 email addresses, just put it on, send it to them. This is really not that difficult or unusual. So the court has already entered the order saying, yes, everybody's going to comply with the rule when it comes to sealing documents, but it tacitly rejects his position that the parties to this action should be burdened with serving every media entity that has sought or will in the future seek notice of request to seal or close with notice of such proceedings, since they are or should be available to the public through the court's docketing system. Of course, we're going to comply with the order. But in their motion for limited intervention, they seek a more formal status in this litigation, which is significantly broader than that provided for by Utah law and the Utah rules of court, and broader than that which is required by the First Amendment. So they're asking to deny this intervener status. And look, I mean, it's just a 9-page filing. Like, they did a lot of research on this. For I still remain a bit baffled as to why this is a priority. If the issue is simply the pragmatic problem that you pointed out in court last time we were there, that, gosh, if the court puts them in the case system and then they might get access to things they're not supposed to get access to, you could just say that. You could just file a response that says, we recognize the media has a right to participate. They don't want to be burdened with service. And this to me is just wild. That's so not a good argument. Service is just a thing you have to do. But you could just say, we recognize they have a right of access. We're just concerned about some of the pragmatic limitations, and we'd ask the court to bear in mind, these possible issues. And so make sure that anything you do is considering the possibility that they might get inadvertent access to things they're not supposed to be able to see, and to make sure that doesn't happen, that steps are taken to prevent that. But no, they're opposing, they're coming in and like arguing constitutionally that they don't think the media should have this much of an interest in the decisions made about access. And so they have focused heavily on these things like, public's right of access is not absolute. Yes, we know that. We know that. We got to consider the right to a fair trial. Yes, we know that too. Nobody is saying that any of these standards change because the media gets to advocate their position on these standards. So there is no precedent for granting a media entity broad intervener status in a criminal proceeding beyond the specific rule that deals with closure documents. They say. And they say that none of the cases cited by proposed media interveners support their broad contention that courts have concluded that press organizations have standing to intervene in criminal proceedings. They cite civil actions, guys. They only cite civil actions. Criminal cases are different, and only the state and the defendant are actual parties to a criminal action. They do cite to a decision of the Utah Supreme Court resolving media access questions related to a specific sealed competency hearings that were part of a criminal proceeding that had already concluded, the capital trial of Ronald Lafferty. This was the Under the Banner of Heaven case, for any of you guys that have read that book. In the underlying criminal matter, the district court sealed Lafferty's competency hearings and the resultant memorandum opinion finding him incompetent in order to protect his right to a fair trial. But it did so without giving the media an opportunity to be heard on the need for closure sealing and without making specific findings that supported the orders. So after the trial concluded, the media entity filed a petition for an extraordinary writ seeking an order from the Utah Supreme Court directing the district court to conduct a closure hearing and make findings concerning whether the disclosure of the competency hearings and the court's rulings on the competency issues, got some cat issues here, would impair Lafferty's right to a fair retrial. The Supreme Court ordered the district court to do so, but it doesn't confer permanent intervener status on the media group. Rather, Bullock requires district courts to convene a hearing at which they can be heard and for the district court to make findings on the need to keep sealed the records of that competency hearing and the court's rulings thereafter on the competency issues. And this is the process now contained in the judicial rule that deals with documents. There is no rule applicable to criminal proceedings that allows for intervention by third parties like the proposed media interveners. They have chosen, they say in other circumstances, in criminal cases, not to imply the civil intervention rule. And they're entitled to notice and the opportunity to be heard regarding motions to reclassify court records and closure requests. In this regard, they have standing. However, the court should not permit the proposed media interveners to become a named party, even a limited purpose party in this case. Doing so would afford the media direct notice of all filings. That's not what they're asking for. They're asking for limited status, not just those they are entitled to under the court's order. There's no citation for this. Like, I don't know what legal principle, what legal rule is out here that you're relying on to say that this is what is inevitably going to happen. Doing so also creates concerns with the security of the record, specifically ensuring court records that are properly classified as private, sealed, or closed are not accessible to the media from the point of filing to the temporary classification by court staff and to the ultimate decision on the classification. This is the pragmatic concern. And this, I understand this. This does seem somewhat legitimate. But this also seems fairly easy to work around. You can work around this with things like maybe you just don't put them in the, in the court system like that. Don't know how their court system works. If there is a way to kind of limit what somebody has access to. Another possibility is you just include as part of your order that should counsel through this system get access to any of this stuff, they are to not share it, they are to disregard it, they are to treat it as counsel's eyes only, which kind of seems to be how Utah handles a lot of these things, because that's how they handled the closure hearing the last time, right? They just brought the attorney back into chambers and had their whole conversation, and presumably he doesn't get to talk about it. He doesn't get to share, any of what happened back there. And that's just part of your responsibility as an officer of the court when you're an attorney. That you gotta abide by orders like that. So that to me seems like a pretty easy fix. To the extent there's any problem with it, just order them. That they're not to, you can order them, you can like craft that however you want. Like, don't look at things unless you have a good faith belief that they involve access issues. If you happen to see something that you shouldn't have had access to, then don't share it with anybody. Treat it as attorney's eyes only until there is further direction from the court. A lot of ways that you could deal with that. So that's, that's his response on this one. A fair amount of work and like constitutionalizing an issue that ultimately seems to not really. I don't get the priority other than the fact that we are seeing a kind of generalized, broad hostility to public interest in the case coming from primarily the defense. And that, I mean, that should say a lot. It should say a lot. If I'm defending somebody and I got a great defense and I got a lot of evidence and I've got all kinds of holes in the prosecution's case, I don't want to hide that from the cameras. Okay? I want the cameras there every single time I have anything going on, so that message can be shared, so it can be clear that there's going to be another side to this case, and maybe I can't tell you like every single detail, but I can at least make it clear in the public consciousness about this case that there's reasons to be skeptical of the accusations that the public has heard about coming from the prosecution. If I have that, I don't want it to be hidden. And so it raises some serious questions for me about what exactly they have. And so perhaps the issue here is that they don't have that, and that in fact there is a strong basis for the prosecution. The evidence coming out isn't going to favor the defense. And so they want us to hear as little about it as possible until we get to the critical stages where it can't be avoided. And the most obvious upcoming one on that is going to be the preliminary hearing. So I'm just kind of checking to see if this hearing goes live, because sometimes they like to. Yeah, over on. Let me share this here, guys. Let's see, are we seeing that? Okay. Let's get him going.
Court is now in session. Counsel, let's call the case. Calling case 251-403-576, State of Utah versus Tyler James Robinson. Could the parties please enter their appearances?
Governor Christopher Ballard, Chad Grunander, Lauren Hunt, and David Sturgill on behalf of the state.
Good morning.
Catherine Nestor, Michael Burt, Richard Novak, and Stacy Visser on behalf of Mr. Robinson.
Good morning, counsel.
Good morning, Your Honor. Jeff Hunt and David Ryman on behalf of the Deseret News, KSL, and other media interveners.
Good morning, Your Honor. Michael Judd on behalf of the Salt Lake Tribune and other media interveners.
Thank you, and good morning to you. Mr. Robinson, are you with us?
Yes, Your Honor.
And Mr. Robinson, good morning to you as well. All right. The court appreciates the patience of the parties while it considered issues raised by the media interveners, an appropriate classification of the transcript and audio recording from the October 24th hearing. The court has taken the necessary time to conduct a careful, independent review of the written submissions, oral arguments, and applicable legal authorities, and to thoughtfully evaluate the matters presented. In doing so, the court has remained mindful of its duty to balance competing constitutional interests. Openness and transparency are foundational to our judicial system and essential to maintaining public confidence. At the same time, the public's right to access is qualified, not absolute. and may be limited when a legally sufficient justification exists. The court recognizes the substantial public interest in these proceedings and has approached its review with that interest firmly in mind. The court has independently reviewed the October 24th transcript and audio recording in its entirety in determining whether any restrictions on public access is warranted. The court considered whether such limitations are necessary to protect specific constitutional interests and whether less restrictive alternatives could adequately address those concerns. The carefully limited redactions ordered are narrowly tailored and designed to protect those interests while preserving the public's ability to understand the substance, context, and significance of the proceedings. By way of context, the transcript of the October 24th hearing consists of 83 pages, 80 of which contain verbatim record of the proceedings. Each page includes 25 lines of text, and the transcript reflects just over 2 hours of the courtroom proceedings. The duration of the hearings was 2 hours and 19 minutes. The closed hearing held on December 11th included detailed arguments from defense, prosecution, and counsel for the news media regarding what portions of the record should remain private and what should be made public. That hearing likewise lasted nearly 2 hours, during which time counsel addressed these issues carefully, line by line and word by word. The court acknowledges and appreciates the diligence, professionalism, and preparation demonstrated by all parties during both hearings. After full consideration of these arguments, the court determined that 246 words, approximately 1 page of the 80-page transcript, should be redacted. No other portions of the transcript were found to warrant restriction. The court further notes that the matters addressed during the October 24th hearing, including issues related to civilian clothing and shackling, are best understood when considered in their full context. The limited scope of the redactions reflect the court's effort to preserve that context to the greatest extent possible. The redacted transcript will be promptly filed on the docket by the end of today. The corresponding audio recording will require additional time to ensure that it precisely reflects the approved redactions and that no protected material is inadvertently disclosed. The court anticipates the audio recording will be available within approximately 2 weeks. This court notes the importance of the audio in addition to the transcript, because hearing what was said and how it was said is equally as important as just the transcript itself. The court's sole objective in this process has been to ensure a fair, orderly, and lawful proceeding that reflects the constitutional rights of the parties while honoring the public's qualified right of access. The court notes that the standing decorum order has also been updated and directs all parties to review the order in advance of future hearings. Accordingly, the court now issues the following order regarding the classification of the transcript and audio recording of the October 24th hearing. And turning to the order itself. The state of Utah and defendant Tyler James Robinson filed a motion to classify the transcript and audio of the sealed October 24th, 2025 hearing as private. Because the press requested notice of all such motions, the court held a closure hearing on December 11th, 2025 to address the classification of the transcript and audio recording of the October 24th, 2025 hearing. Prior to that closure hearing, the parties filed a joint status report identifying some 20 provisions of the transcript for redaction and stating that the balance of the transcript may be classified as public. Having reviewed the relevant pleadings from the parties and representatives of the press and heard oral arguments during the December 11th closure hearing, the court now rules and orders as follows. The public has a presumptive right to access court records. See Utah Rules, Judicial Administration 202.02 sub 1. That right, however, is not absolute. To support and achieve certain interests and objectives, a court may close portions or entire court records. A court may consider any relevant factor, interest, or policy, both in favor of and opposed to closure, in determining whether to redact portions of or close all or part of a court record. In deciding whether to redact or close a court record, a court must balance the interests favoring opening and closing the record, and if it determines to close the record, determine there are no reasonable alternatives to closure. The parties have argued, and the court has considered, the following policy interests in determining the motion. 1, protecting safety interests. 2, protecting privacy interests and non-party participants. And 3, protecting the defendant's right to a fair trial. Approximately half the portions of the transcript the parties seek to redact address courtroom and courthouse security measures. Safety concerns are well recognized as justification for closure of court records. This undoubtedly includes references in the court record to specific safety measures undertaken as part of the court security plan and practices in highly publicized cases. This case generates extraordinary ongoing national and international attention, some of which is threatening in nature to the parties, their representatives, and non-party participants. The safety and well-being of all involved in this matter outweighs the interests of the public that are served by open court records. Nevertheless, and as the parties recognize, the court need not seal the entire transcript and audio of the October 24th, 2025 hearing to protect the safety interests of all those involved. Redacting selective portions of the transcript and the audio that reference security measures will serve safety interests while allowing for as much public access to the remainder of the record as possible. The court hereby orders the redaction of the portions of the transcript corresponding audio referencing security measures identified in the parties' joint status report and further pared down during the closure hearing. These include the following portions of the October 24th, 2025 hearing transcript. Page 4, line 19 through 22, following the word unshackling until the sentence begins with the word and. Page 4, line 25 until page 5, line 1, including the first sentence of the last paragraph. Page 5, line 9 through line 10, following the word proceeding and ending before the word but. Page 5, line 18 and 19, including the entirety of the bailiff's comment. Page 33, lines 17 through 18, following the word courtroom until the end of the sentence. Page 34, lines 5 through 7, following the word arrested until the end of that sentence. Page 35, lines 24 through 25, including the last sentence of that page. Page 36, line 1, including the first word on the page until the sentence begins with the word that. Page 40, line 12 through line 16, following the word outside until the word maybe. Page 41, line 17 through line 21, following the word on until the end of the paragraph. Page 43, line 11 through line 13, following the word jail and ending before the sentence begins with the word and. Page 55, lines 12 through 13, following the word people and ending before the sentence beginning with the word so. page 64, line 18 through 19, following the word been until the end of that paragraph. And finally, page 70, lines 1 through 3, following the word clothing until the sentence begins with the word I'm. Protecting personal privacy is a recognizable justification for closure of a court record. To justify the closure of a court record, a privacy interest must be more than a desire to avoid annoyance, criticism, or embarrassment, and must serve to protect information of a highly personal nature. The parties initially identified 6 portions of the transcript to be redacted based off privacy interests. During the closure hearing, the parties withdrew defendants' requested numbers 1, 2, and 11. The remaining 3 requests were significantly pared down. The court has already ordered the redaction of request 3 for security reasons, including page 34, lines 5 through 7, as ordered above. The court also finds that privacy interests support this redaction. The court has considered the interests favoring closure of the remaining 2 requests for redaction and concludes that the information is not of a highly personal or sensitive nature. Privacy interests do not outweigh the public's interest in this case. Therefore, the court denies redactions of the following portions of the transcript: page 35, lines 16 through 17, and page 80, lines 22 through 25. The right to a fair trial seeks to ensure that the one accused of a crime will have his guilt or innocence determined solely on the basis of the evidence introduced at trial. Thus, if disclosure of information poses significant risk of endangering a defendant's right to a fair trial, then closing or sealing a court record to protect that information is justified. Nevertheless, when such information has already been introduced to the public arena, there is a suggestion that no additional damage can be done, and the issue of sealing or closing the record becomes moot. Here, the joint status report identified 4 portions of the transcript for redaction based on the argument that redaction is necessary to preserve defendant's right to a fair trial. The court is unconvinced that the disclosure of the selected portions jeopardizes that right. The information in question is contained in the charging instrument, whether directly or indirectly, as part of the factual allegations made against defendant and already part of the public arena. If this information poses a risk of violating defendant's right to a fair trial, defendant's first line of defense is found in the rules of evidence and criminal procedure. Closing or redacting these portions of the transcript and audio is outweighed by the interests and the objectives served by open court records and mooted by prior disclosures in the information. Therefore, the court denies the request to redact the following portions of the transcript and audio: page 55, lines 2 through 7, page 60, lines 24 and 25, page 61, lines 1 through 6, and 13 through 14, page 64, lines 11 through 17. These portions also refer to a potential non-party witness. The court has considered redaction to protect the non-party participant from risk of retaliatory physical or mental harm. However, the reference is made to that non-party participant during the October 24, 2025 hearing offers the same but no additional information that can be found in the charging instrument and shared by law enforcement during a press conference. As a result, redacting those portions at this point is a moot issue. For the above reasons, the court orders the following: a transcript of the October 24, 2025 hearing shall be redacted in accordance with this order and entered into the record, and the audio recording of the October 24, 2025 hearing shall be unsealed for the purposes of the court clerk identifying the timestamps corresponding to the redacted portions of the transcript, which selected portions once identified shall be resealed. No copy of the unsealed audio shall be provided until the identified portions have been resealed. The court will sign this order today, and it will go into the record. Now, turning to the second issue. And the court now issues the following order regarding the media's request to intervene. Two groups of media outlets seek to intervene in this matter. Only the state and the defendant, however, are actual parties to a criminal action. The press need not be a party to a criminal action to pursue the public's presumptive right to access public court records. The press has already been provided with a mechanism through Rule 4-202.04 to protect that right and has already utilized it in this matter. For this reason, the court denies both requests to intervene. The court now reiterates and clarifies its order requiring parties to serve all closure or reclassification motions on the media dated November 10th, 2025, as follows. Again, the parties are ordered to serve all closure motions on members of the press who have requested notice. The parties must file proof of service with the court. A closure motion is any motion to classify or reclassify presumptively public court record under Rule 4-202.02 as any other classification. The parties need not serve notice on members of the press court records that are presumptively not public. A court record means a record that is prepared, owned, received, or retained by this court. This includes hearings. Therefore, the parties are ordered to serve all motions to closure hearings on members of the press who have requested notice. The parties must likewise file proof of service with the court. Nonetheless, the parties are not required to serve notice on members of the press of motions to limit electronic media coverage. If members of the media intend to object to a closure motion and request a closure hearing, such objections and requests must be filed within 7 days of receiving notice. To promote judicial economy and to eliminate unnecessary hearings, the court may decline to hold a closure hearing if no hearing is requested. The foregoing should be treated by the parties as a standing order for the duration of this case. And that concludes the second order of this case. The court wishes all parties a peaceful holiday season and hopes that each of you is able, to the extent possible, to spend time with your loved ones. The next hearing is set for January 16th at 1 p.m. And Mr. Robinson, I will see you there at that time. Court is now in recess.
Everybody can come back to life. Isn't it like, does it remind any of you folks in there like me, get your Shavasana in, you know, the nice end of a yoga session, and you just get into that deep, relaxing stage. It's just like yoga court. It really is. It's it's not like any experience I've ever had in court with this judge. I swear, I know it's not just me. I find it so relaxing, calming, listening to him. Just everything kind of brings the volume down. Well, let's recap, because I didn't write down like each and every detail of the pages and the words and so forth of the redactions, but here's basically what he ruled. So the first thing that he was addressing was the transcript from the October 24th hearing. Because the October 24th hearing was closed, the transcript is presumptively private. So the media had requested to reclassify it subject to redactions. So at the last hearing, that's what they spent the first 2 hours doing, was going back into chambers to talk about what, if any, portion of this transcript can and should be released publicly. So the parties had kind of proposed what they thought, these are the things that absolutely can't be made public, and everything else can go ahead and be released. The court reviewed those. The media had an opportunity to participate in that conversation as well. So we have an 80-page transcript, 80 page of verbatim reports of proceedings, and out of that, a total of about 1 page is being redacted in all of these different sections. So there are 3 areas that were like justifications that were offered for closing off, redacting part of the transcript, basically saying we can't see this. We can see everything else, but we can't see this part. So the court safety issues were one. And so this is going to deal with things like the court has a security plan for how do we provide courtroom security? How do we transport people to and from the jail? How do we, vet people coming in the front door? All of these types of issues. And for operational security reasons, they are not necessarily going to make all of that public. Who's armed, what they're armed with, what, kind of protective gear that they have and stuff like that. Because the more that information is public, the easier it would be to find a way to work around it. So that has justified, in the court's view, certain redactions. The second basis was personal privacy. Now, personal privacy, as he said, it's typically got to be more than just this information could be potentially embarrassing. It has to have some sort of independent recognition as being especially sensitive information. And so this is going to typically involve things like personal identification, like your social security number and stuff like that. Your financial information, your, account records, things like that. But it can also include personal medical information. So, and this one, he said there were 3 that he found, 3 points where he found there was personal privacy information that justified redaction. One of those, he said, overlaps with a redaction that he'd already granted for purposes of court security. I have some kind of thoughts and suspicions about what this means. I mean, I suspect this has to do with either precautions or like evaluations, things that have been done with Mr. Robinson in jail to kind of evaluate how are we going to hold him. Is he going to be, does he need to be like medically supervised? Does he need to be on suicide watch? Does he need to be in secure, away from other people? Those types of considerations that, again, they're not going to tell us about publicly necessarily, but it can overlap with things like, medical checked him out and found XYZ, therefore we did this particular action. So I suspect that's likely what that one, that one redaction that fit within both categories. It probably has something to do with that, with like his medical clearance, his suicide precautions, things of that nature. The last one was information that poses a significant risk of a fair trial, of jeopardizing a fair trial. So basically, seems to contemplate that evidence or information coming out other than through the adjudicative process can potentially justify, sealing it if it's something the court needs to know for purposes of making some type of a decision based on it, but doesn't, we're not adjudicating his rights right now, so the public doesn't necessarily need to know, they say. Then that can justify a closure. The parties had suggested there were 4 areas that required closure required redaction based on that consideration, and he rejected all of them. He said, no, none of those are going to warrant the public not hearing about it because there's nothing significantly different from or added to what is already public information. either in the charging documents or in the press conferences, other like formal communications that have already taken place about the case. Mention of a non-party participant. A non-party participant. That's a very interesting way of characterizing it, because participant, sounds like a participant in the crime, but not a party. Not a party means not charged, not a co-defendant. Makes me wonder if we're talking about a informant. Somebody flipped. Is this Lance that we're talking about? I don't know, but I definitely seized on that language of a non-party participant. It's very specific and unique language. It's not a witness. It's not just a third party. A non-party participant. I don't know. Maybe that means something special in Utah. Maybe it's just a fancy way of saying a witness or something, but stood out to me. Kind of curious about that. So based on that, he has ordered the very specific redactions, this line from this word to this word, to be made to the transcript as well as to the audio recording. We are anticipated to get the transcript on the docket today, by the end of the day today. So I will be keeping my eyes out for that and see if that pops up. And if it does, you can check out the legal archive I've got going on over on Substack. If I'm able to get it, I will post it there if you are interested in taking a look. So on the intervention, so he's ruled that the only parties in a criminal case are the state and the defendant. So the media doesn't need to be a party to get essentially what they're asking for. So he's denying their request to intervene, but he's also saying, under the rules, you already have to do these specific things in terms of serving them, giving them notice, providing them with filing a proof of service, doing all the things you need to do to make sure that they have an opportunity to participate. They do have to file a response within 7 days of getting a hearing like that. The only thing that they had asked for that he said he's not going to require the defense to do or the state is to serve on the media, specifically motions to limit electronic media coverage. So to take the cameras out of the courtroom, they don't have to specifically serve the media with that. I don't think that's going to preclude the media from participating in it if they choose to. If the motion gets filed and they request to be heard, I kind of tend to think he's going to go ahead and allow that. He's just not going to pre-require it, as a condition of filing a motion like that. So that's pretty much what we got today. 1 p.m. on January 16th is the next hearing. So that is when we have the motion to disqualify set for hearing. I do have that ready to just go ahead and look at so that we can see what's going to be going on with that motion. Okay, you guys can see it. So I'll go ahead and share that. There are some redactions to it, basically to kind of limit our ability to figure out who it is that we're talking about. It seems to be the nature of what is being redacted here. So they're moving to disqualify the Utah County Attorney Office due to a conflict of interest. Mr. Robinson seeks an order of this court finding that somebody representing the state of Utah in this capital prosecution has a concurrent conflict of interest based upon personal connections to a direct witness/victim to the events at issue in this case. Further, he seeks finding from the court that, one, upon learning of the conflict, the attorney's office did not employ any screening protocol, meaning they did not block this particular attorney from being able to get information about the case, participate in it in any way. And two, information pertaining to the personal involvement of Mr. X was shared amongst the assigned prosecutorial team, including the county attorney. Based upon these findings and in the interest of protecting Mr. Robinson's federal and state rights due to due process, Mr. Robinson requests that this court order that the UCAO is disqualified from representing the state in this matter. So it sounds potentially serious. Let's get into specifically what the relevant facts are. So on September 10th, 2025, Charlie Kirk, the leader of Turning Point USA, appeared on the Utah Valley University campus in Orem, Utah, to engage in a prearranged presentation to students and other observers participants. At approximately 12:23 p.m., Mr. Kirk was shot and killed. It has been estimated that approximately 3,000 students and other observers participants were present at the time of the shooting. Of course, the scene was chaotic and for many in attendance, life-changing. One witness described hearing the shot, seeing Mr. Kirk, and observed that the crowd all collectively dropped to the ground. This is a statement of GC. After a few moments, the crowd collectively got up in unison and started to panic and run. As he and his friends reached their vehicle to leave, they all were hysterical. Another witness who was 40 to 50 feet from the Turning Point booth described seeing the shooting and her cousin getting in front of her. The witness got down on the ground, trying to make herself as small as possible. She thought more shots were coming and it was going to be a mass shooting. She and her cousin sprinted to the nearest building where she grabbed the nearest trash can and threw up. She described it as traumatic and she can't stop replaying the event in her mind. Another witness offered, the atmosphere was of pure panic and I was scared for my life. These all seem pretty understandable to me under the circumstances. They have no idea what is happening, and you're in that state of trying to kind of make sense out of what's happening. Your brain works in a protective way. It tries to reassure you. It tries to keep you from being overwhelmed by fear and stuff like that. And so I would suspect that there's just a lot of complex psychological things going on in the course of experiencing something like this. You're trying to make sense of what you see. Your mind is telling you not to believe it, right? Because it's extremely threatening. And so you're trying to reconcile everything that's going on, not being sure what's coming next. This would be absolutely terrifying and extremely traumatic, and all of this seems perfectly logical to me. So 3 different witnesses have provided these statements about what it was like being in the crowd. Now we have some more. Another witness stated, right away, everyone was on the ground trying to protect themselves from the possibility of more shots. I remember thinking I could not get low enough and I was instantly scared. I struggled to text my mom that I was safe with shaking hands. Yet another witness shared, we were in shock in the crowd because there was so much blood. I was pulled to the ground and started praying. I thought I was about to die. I was on the ground wondering when the bullet was going to hit my back. I was so terrified that they wouldn't find the shooter and he'd start aiming at us. Yeah, you remember this this configuration, how this is set up. They're just all out in the open in this like grassy kind of amphitheater. And so there's no cover. There's no security. And if you're at the mercy of whatever that shooter wanted to do in that instance. And if he had wanted to, shoot into the crowd, yeah, it could have been a lot worse for a lot more people. So just the helplessness would be, completely overwhelming. So 5 different witnesses specifically there describing their circumstances. Even those who were present on campus but who did not see the shooting themselves were impacted and significantly traumatized. Students were locked down in classrooms, experienced panic attacks, and experienced the traumatic aftermath comparable to those of direct observers. And Exhibit X is apparently a lot of TikToks. On September 16, 2025, Mr. Robinson was charged in a 7-count information with aggravated murder. The aggravating circumstance for this offense is that the defendant knowingly created a great risk of death to another individual other than Charlie Kirk and the defendant. The state has not yet identified the other individual supporting the aggravating circumstance. Also on September 16, 2025, Utah County Attorney Jeffrey Gray gave an hour-long press conference explaining the state's intention to seek the death penalty against Mr. Robinson. Blank and other members of the prosecution team were present at that press conference. During the press conference, Mr. Gray conveyed, "I also want to express my concern for everyone who is at Charlie's Turning Point USA event at Utah Valley University and all who have been impacted by this tragedy." Unfortunately, one of the students in attendance at the Charlie Kirk presentation on September 10th was the blank of Mr. Blank. At the time of the shooting, Mr. Blank was with Utah County Attorney Jeffrey Gray at a presentation in Davis County. Mr. Blank began receiving text messages from his blank and shared those with Mr. Gray in real time. Mr. Blank also called another attorney at the UCAO almost immediately, told him about the shooting, and shared his blank's texts with him. Mr. Blank has described the text message exchange as follows. Charlie Kirk was shot at 12:23 p.m. and at 12:25 p.m., Blank texted my family text group, "Someone got shot." And almost immediately afterward, Blank texted the same group, "I'm okay, everyone is going inside." At 12:26 p.m., Blank texted the same group, "Charlie got shot." At 12:30 p.m., Blank texted the same group, "People say he was shot in the neck and his head like tilted or something." At 12:23 p.m., I texted my blank, "Did you hear a gunshot or what sounded like a gunshot?" Blank responded to me at 12:38 p.m., "I for sure heard it. Everyone started screaming and running. A few people said they saw the shot hit his neck. Not sure." Mr. Blank believes that he discussed his blank's presence at the event with others in the office at the time. He also discussed the exchange and the potential conflict issue with the entire prosecution team prior to disclosure to the defense. Mr. Blank holds a supervisory role at the UCAO as the blank under Mr. Gray. At the request of Mr. Blank, he and a UCAO investigator went to the UVU campus to determine the exact distance his blank was from Mr. Kirk. His blank was approximately 85 feet to the northeast of where Mr. Kirk was seated when he was shot. His blank's backpack was left in the amphitheater as blank fled the scene. Mr. Blank disclosed this information by email to Mr. Robinson's counsel on October 1st, 2025. Defense counsel Mr. Blank and another prosecution team member, Christopher Ballard, spoke about this issue on October 9th, and additional information concerning communications within the UCAO was provided at that time. Mr. Blank has stated to Mr. Robinson's counsel that his blank will not be a witness for the state and that he does not believe that this circumstance presents a conflict precluding him from participating in the prosecution of Mr. Robinson. Mr. Blank provided the same information to the State Bureau of Investigations. So bottom line, he's got a relative or close friend, presumably a relative because this is in the family chat that he describes, who was there and who told him about what was happening at the time. So this presents a potential conflict of interest because of the possibility that this person could be called. And so if this person is called, the issue is Mr. Blank going to be able to effectively cross-examine or, examine this witness in light of having a potential personal relationship that might bias you to act, more favorably towards this witness in one way or the other. The prosecution is saying this isn't an actual conflict because we don't intend to call this person as a witness. And just from what's recounted, there doesn't seem to be anything about this witness that makes them necessary. We already got 5 descriptions from other people of what happened, to like from the eyewitness perspective of somebody who was just present at the talk. So there's nothing that we've seen from this exchange that suggests that this particular witness has any unique or extraordinary information that would necessitate that they be called, as opposed to any, those five, or like anybody else who they happen to know was present at the time. So that's our posture. It's a potential conflict of interest posture. It's not an actual conflict because it hasn't materialized yet, but it's potential because it could materialize. And so potential conflicts of interest, I'll just tell you, as the defense lawyer, we deal with them all the time. And the reason why, especially in a small community, and the reason why is because crime tends to cluster. And so the same people that tend to be perpetrators of crime one day will be victims of crime the next day. They will be witnesses in cases on another occasion. And so you're often dealing with the same people over and over and over again in different contexts. So you have to be, when you're a defense attorney and you get a new assignment, you get a new case assignment, and you get the police report and you see, oh, here's somebody that's named as a witness. I know this person. I've represented this person in the past. That means I got a potential conflict of interest. So I'm going to have to look at, what is this witness's role in this case? Is this witness aligned with me? Is this witness adverse to me? Then I also have to evaluate, is there anything about my representation of this person that is going to make this more likely to materialize into an actual conflict? And so the circumstances where that could come up would be, number one, I'm actually currently representing this person, and I'm being put in a situation where I might have to deal with this person as an adverse witness. So on the one hand, I'm their lawyer looking out for their interests. On the other hand, I need to, vigorously represent my other client by potentially, tearing this person a new one on the witness stand. Those things can't be reconciled. And so if that's the situation, that potential conflict is going to warrant me having to get out of the case. But if it's a situation where I'm no longer representing this person, I represented them on something like completely unrelated in the past, and they're generally friendly to me, to my client in the new case. It's not a situation where perhaps information that I learned from them or about them during the course of my prior representation might be relevant in the subsequent case, because I need to cross-examine them with it or something like that. That would be a big problem that would require me to get out as well. But if it isn't anything like that, then it's a potential conflict that is going to allow me to proceed. Because unless something kind of unforeseeable or strange happens, it's not likely to materialize. So as a defense lawyer, you're kind of constantly dealing with these kinds of issues real frequently and evaluating, its potential, how likely is it to materialize. It's probably less often that the state's attorney or the county attorney, deals with these types of situations, because they don't represent clients, they represent the state. And so they're going to be dealing with these far more limited circumstances where it's typically just going to be based on things like this. My business partner is charged with a crime. Yeah, you're going to have to nope on out of there because you have a financial, relationship with this person. And so an interest in not undermining their ability to continue making you money, for example. Family relationships typically gonna be a problem. If your family member is charged with a crime, you're probably you're definitely not going to be able to prosecute that. And whether your office as a whole is going to be able to prosecute that could just depend on things like, are you being screened away from it? What is your role? If it's like the elected, has a kid who gets charged with a crime, chances are pretty good that whole office is going to get disqualified, because you can't really take out of the picture the incentives of everybody in the office to keep the big guy happy so that you can keep your job and you can get your promotions and things like that. So these are just like some examples of conflict situations to kind of illustrate how it's not always real crystal clear. It's very fact specific how these things work. And, you know, one little change of the facts can change the situation pretty dramatically. What we seem to have here is we seem to have a supervisor. So we have a lot of these same kinds of considerations that you'd have if the elected themselves, you know, gets has a personal relationship that's potentially adverse, because the people that they supervise aren't gonna, you know, they might be a little hesitant to piss your boss off by, you know, if this is, say hypothetically, because we don't know, but say this is his son, you're gonna go like cross-examine the hell out of your boss's son, and you just, you know, everybody's going to be kind of worried about what are the potential downsides of doing that. So it puts you in a situation of having to choose between my responsibility as a lawyer in presenting the case and my personal interest in having job security and stuff like that. So the supervisor is a factor that may matter here. The nature of the relationship, if it's family, you know, that's you're kind of presumed to be biased in favor of your family. But what's cutting against this is the fact that the witness doesn't seem to be necessary at all. And the defense, at least in these facts, haven't suggested that there's anything that this witness has to say that would, you know, make them unique or special beyond anybody else that could be called to establish these same general facts. So let's go to their argument. Mr. Blank's conflict of interest requires his disqualification as his continued participation in the prosecution would violate Mr. Robinson's state and federal due process rights. Mr. Blank's familial relationship with a witness presents a concurrent conflict of interest and disqualifies him from participating in the prosecution of this case. Mr. Robinson's due process rights require Mr. Blank's removal from the prosecution of this case. Let's stop right here and talk about how this is being framed. You remember how when it came to the gag order, the defense was like, it's not hard to understand what a witness is. Everybody knows what a witness is because you know who you're going to call and you know who you're going to subpoena. Now we have shifted. We're using a different framing of witness here, where even though we've acknowledged the state says they're not going to call this person, so they're not a witness in that sense that the defense was urging that the court use before. They're a potential witness, but you don't get an actual conflict of interest, one that actually exists, unless you have somebody that is going to be on the stand subject to questioning. So I find that I find it notable, the kind of shifting of how the language is being used depending on the outcome that is being sought here. But that is the reason why they're doing it, because they want to, you know, bolster the significance of this relationship. And the only way to do that is to make this person an actual witness rather than a potential witness, because that's the only way you get an actual conflict rather than a potential one. An actual conflict is pretty much always going to require disqualification, but a potential conflict may or may not. Under the Utah Code Section 1768-501, attorneys who serve as a public prosecutor shall conduct on behalf of the state all prosecutions for a public offense committed within a county or prosecution district. Attorneys serving as public prosecutors are ethically bound by statute according to the following. An attorney exercising public prosecutor duties under this chapter 1 is a lawyer representing an organization as a client under the Rules of Professional Conduct, Rule 1.13. 2 represents the state as an organizational client. 3 is considered the representative of the state. And 4 is empowered to make commitments for and decisions on behalf of the state. Like all Utah lawyers, those serving as public employees are also subject to Utah Rules of Professional Conduct 1.7, which outlines when a lawyer shall not represent a client because of a concurrent conflict of interest. A prosecutor has the responsibility of a minister of justice and not simply that of an advocate. This responsibility carries with it specific obligations to see that the defendant is accorded procedural justice and that guilt is decided upon the basis of sufficient evidence. To this end, it is clear that a prosecutor should be disqualified on a timely motion when he has a personal conflicting interest in a case. So far, no dispute with any of this. This is fairly uncontroversial exposition of the law. Relevant here, a concurrent conflict exists if there is a significant risk that the representation of one or more clients will be materially limited by the lawyer's responsibilities to another client, a former client, or a third person, or by a personal interest of the lawyer. So a lot of parts to this rule. Significant risk, that's where you get into actual versus potential conflicts. If it's actual, then yeah, there's pretty much always going to be a significant risk. If it's just potential, then it can depend on how likely is it to materialize. The representation will be materially limited, not just sort of affected, not just it might cross your mind, but your ability to do your job is going to be materially limited by this personal interest. That's the conflict of interest rule. Utah courts have found that such a conflict exists when counsel may make choices advancing other interests to the detriment of his client. Such conflicts are only waivable in specific circumstances. I'm going to want to go, in fact, let me see if I can find this real fast because I really want to see this case. This is out of Utah. Because that's such a it's a very general statement. And I'm kind of curious, about the context of it. Let's see, I've got it right here. Let me go ahead and pull us over here. State of Utah versus Oswald Balfour. Let me make sure this is right. 2008 Utah App 410. Yes, this is our case. So he also filed a motion to disqualify the district attorney's office. We affirm the trial court's rulings on the first and third, and we affirm in part and reverse in part. So the motion to disqualify whatever the trial court said was affirmed. So they charged him with unpleasant crimes. He was bound over. These are the counts. I don't really know that we necessarily need to know all those facts because these just aren't real pleasant cases to read for anybody. Okay, he had a prior relationship with the district attorney. During the course of plea negotiations, Balfour requested a meeting between his counsel, district attorney, and the assigned state prosecutor. During this meeting, the district attorney recognized Balfour's name and realized his business was the media company she used, free of charge, during her election campaign. Oh, so she had gotten a financial benefit from this guy. He provided her with pro bono free media assistance. She also realized Balfour was an active member of the Salt Lake County Republican Party, which had campaigned for her election. In response, the district attorney immediately removed herself from further discussion of the charges. Balfour and his counsel later requested that the entire office be disqualified from prosecuting the case. The district attorney declined, instead assigning supervisory authority over the prosecution to an assistant district attorney. Balfour's counsel suggested that the issue of whether the entire office should be disqualified be submitted to the Utah State Bar Ethics Advisory Committee. The assigned assistant district attorney indicated that he would need the district attorney's approval to bind his office to the committee's decision. So, challenges the trial court's decision to deny his motion to disqualify the entire Salt Lake County District Attorney's Office. Trial courts are generally allowed considerable discretion in granting or denying motions to disqualify counsel, and such decisions will only be overturned when that decision is exceeded. That means they got a lot of leeway to decide how serious they think this problem is. However, due to the special interest in administering the law governing attorney ethical rules, a trial court's discretion in situations implicating these rules is limited. Thus, attorney disqualifications are reviewed as mixed questions of law and fact. First, we review the district court's factual conclusions under a clear error standard. So, in other words, only if they're completely contradicted by or unfounded in the record do factual findings by the district court get overturned. If there's anything in the record that supports them, it's going to be upheld. Second, we review the district court's legal interpretation of particular ethical norms under a de novo standard when that interpretation implicates important constitutional rights. So the interpretation of the ethics, they look at, the reviewing court will look at independently. The facts, the district court has almost exclusive purview to get to decide what the facts are. So we'll skip through these other issues because we don't really care about them. Motion to disqualify. He contends the trial court erred by refusing to disqualify the entire Salt Lake County District Attorney's Office due to the pre-existing political relationship between the district attorney and Balfour. The record demonstrates that upon learning of her relationship with Balfour, the district attorney immediately removed herself from further involvement with the case and assigned supervisory authority to an assistant district attorney. So we already have a factual distinction from what we're dealing with in Mr. Robinson's case, where the attorney has not removed himself from further involvement, has not been screened out of the case or anything like that. Balfour argues that these screening actions are insufficient for three reasons. He's entitled to supervisory review by an elected prosecutor. The assignment of supervisory authority to an assistant district attorney was merely illusory, and he is unlikely to receive any lenient treatment or have the charges dismissed due to the district attorney's fear of an appearance of impropriety. So in Utah, a conflict of interest exists when counsel may make choices advancing other interests to the detriment of his client. The duties and prohibitions of a district attorney are outlined in the statutes. While the statute prohibits a district attorney from prosecuting or dismissing any charges against a person the district attorney previously represented, you don't get to prosecute your former clients. It does not expressly restrict her from participating in a case where she has a personal or business relationship with the accused. Nevertheless, Utah courts have found disqualification proper whenever the prosecutor has a conflict of interest with the charges or the defendant. In this case, the district attorney voluntarily recused herself from Balfour's prosecution to avoid even an appearance of impropriety. Check this footnote. Because the district attorney voluntarily removed herself from the prosecution of Balfour, we do not consider whether such recusal was necessary. That's a very interesting footnote. They're just saying she did it. They're implying here she may not have had to. She may not have even had to do that. And that could be kind of important in our case here with Tyler Robinson, because they're saying, you needed to be screened. And this prosecutor, this case, she did screen herself, but the court is implying here maybe you didn't even have to. I don't know. We're not gonna get to that issue. Interesting. So Balfour claims the entire prosecuting attorney's office should have been resolved. When disqualification is appropriate, it is usually sufficient to disqualify the particular attorney with a conflict rather than the entire office. In Utah, when the conflicted attorney represented the defendant in the same or a related matter, the entire prosecutor's office will be assumed to be privy to the confidences obtained by that conflicted attorney. This is pretty typical. This is a kind of a common problem that comes up when defense attorneys either move to the prosecutor's office as staff or run for office and get elected. And then there's a transition, right? You had cases. There probably some of them are still open, and they may be being prosecuted by this office. You can't have anything to do with that because you know too much from the other side. And so in those situations, very common for the entire office to be disqualified out of that representation. But if it's just a situation where I represented this guy in the past and now we're prosecuting him, there's no inference that I know anything confidential about his current prosecution that could, potentially jeopardize my ability to be ethical as an attorney. So even in those cases, however, the state may rebut the presumption by demonstrating that the conflicted attorney has been screened from involvement in the prosecution. The rules of professional conduct also suggest that screening is the most appropriate means of protecting the defendant when the prosecutor has a conflict of interest. Here, the district attorney immediately removed herself from the case and transferred supervisory authority to an assistant district attorney. Thus, even if a presumption of prejudice were imposed, the state has carried its burden of rebuttal. We hold that the court was correct in finding that the disqualification of the entire Salt Lake County District Attorney's Office is unnecessary. So, couple of things at work here. Presumption of prejudice. If there's a presumption of prejudice, then they need to recuse themselves, at least individually, and screen themselves out. So now we have to apply that to Tyler Robinson's case. Is there a presumption of prejudice when the prosecutor personally knows somebody who was there, has a family relationship with somebody who was there, but there's no indication that that person is going to be called? The prosecution has said, we're not going to call them, and the defense has not indicated that they're going to call this person. That's going to be, I think, really the question, because we already know the attorney didn't screen himself out. He's continuing to be involved. So if there's a presumption of prejudice, then it's probably going to, potentially impact what happens with the rest of the prosecutor's office. But, the context here is so different. It's so different because the whole reason the representation of the former client is an issue is because it implicates your ethical duties as a lawyer. You have a duty of loyalty to that person. You have a duty of confidentiality to that person. And so it's very likely that those can come into conflict if you're put on the other side of the dispute. And, now you have a duty to represent your new client, and it's in your new client's interest for you to use that confidential information you got from the first client against them. And that would be like a huge problem kind of structurally for people's ability to trust their lawyers, to not just, switch sides on them and stuff. So it's part of maintaining the integrity of the process that, anytime you're dealing with former clients, there's a lot more kind of strict rules about it because of the fact that you have access to confidential information and you have this duty of loyalty to them. You don't have duties like that with a personal family member. Now, there's going to be perhaps an assumption that you don't want your family member to be treated badly, but it doesn't raise this risk of like undermining the whole way that lawyers work and that the legal system works. If you know something about what your family member went through, that is unlikely, it seems, to be a particular issue in the case. So anyway, that was interesting for me anyway. I don't know if you guys found it interesting or not, but just to get the feel of what the legal context is in this situation. What are they relying on? Doesn't seem to be that strong. It seems to be strong in the sense that if you've got this potential for prejudice, this presumption that your involvement in the case is going to be a problem, then they needed to take action to screen him out right off the bat. But what I don't think we have is an implication here that, having a family relationship with a potential witness is anything at all equivalent to having a relationship with a former client that's now on the other side of the table. So public officers prosecuting defendants while laboring under a personal conflict endangers a defendant's right to due process. As stated by the U.S. Supreme Court, injecting a personal interest, financial or otherwise, into the enforcement process may bring irrelevant or impermissible factors into the prosecutorial decision and in some contexts raise serious constitutional questions. Doesn't Fannie Willis know something about this? Wasn't there some issue down there in Georgia? Yeah, I didn't follow that super closely, but caught enough just kind of out there in the ether to appreciate that, yeah, this kind of came up there, didn't it? Further, a prosecutor violates the requirement of fundamental fairness assured by the Due Process Clause of the 14th Amendment by attempting to serve two masters. In this case, the personal relationship between Mr. Blank and his blank, a potential witness and victim, raises serious concerns about past and future prosecutorial decision-making in this case. Mr. Blank cannot serve two masters and should not be permitted to do so. Now, they have switched now from it's a witness to it's a potential witness, but also a potential victim. I am interested in how does Utah law define a victim? So let me see here. Let me share this real quick. This is the victim's rights in the Utah Code. Let's look at definitions. Victim means an individual, including a minor, against whom an offense has allegedly been committed. Against whom an offense has allegedly been committed. I don't think that somebody who just happened to be there is going to count as a victim under this definition. Let me get the brief back up here. Because the person the crime was committed against was Charlie. And so they had, remember at the last hearing, they had this process of recognizing Erica Kirk as the victim representative. So she is there to represent the interests basically of the estate of Charlie Kirk, because Charlie Kirk is the victim. He can't be his own representative in the case. So somebody has to do that for him. I don't think they're going to count as victims under this framework. If they were counted as victims under this framework, then they are entitled to all of the rights that witnesses have in Idaho or in Utah, and those are pretty extensive. They have the right to participation, the right to notice, the right to often there's victim assistance funds for things like counseling and stuff like that. Yeah, a lot of different things going on by getting a victim status. So that to me seems like that's probably not going to materialize. I don't think this person is going to be considered a potential victim. If you catch me squinting, it's wonderful to have sun coming in the window in December. It's something I appreciate very much, but it is right at that point because I'm kind of far north, and so it's really far south in the sky, and so my window shades don't completely cover it, and yeah. Anyway, it's going to take a minute to. It's probably blasting my face off too, but it is what it is. Mr. Blank's integrity is not the question, and his opinion that there is no conflict is not dispositive. Rather, his Blank's experience raises an objective question as to whether or not the circumstance presents a significant risk that Mr. Blank's personal family interests may materially limit his ability to represent the state of Utah in these proceedings in the manner that is ethically required. In assessing the irreconcilable conflict that exists here, That's pretty conclusory, isn't it? Already establishing there's an irreconcilable conflict. The court should consider that the production of discovery in this case has only recently begun, and there is no way to say with absolute certainty that Mr. Blank's blank will not be a witness in this case. The defense is not in a position to make this assessment and should not be required to do so. Well, no, I wouldn't say that the defense has to go on record right now and definitively say one way or the other, we're going to call this person and we're not going to call this person. But it's a likelihood test. It's a significant risk. It's a likelihood test. And so you have to look at the likelihood that it's going to materialize, that we're going to end up in a situation where this family member is on the stand and this attorney is being expected to cross-examine this family member. That's pretty much the situation. So no, it's not that they have to say whether they're going to call him as a witness or not right at this moment. But the court absolutely has to calculate in what is the likelihood that this person is going to end up in that position in order to evaluate if somebody needs to be disqualified, because it is a potential conflict, not an actual one. Similarly, expecting Mr. Blank to separate his role as a blank with the wholly natural instinct to protect and shield his blank from past and future harm, it's got to be a child, right? It's got to be a child, just the way that this is being written. From his role in the prosecution of the individual alleged to have caused harm to many, including his blank, is not practical and defies common human experience. As described by witnesses on campus at the time of the shooting, the event and the aftermath were harrowing, even for those that did not see the shooting as it happened. Mr. Blank and his blank are not immune to this trauma. There must have been fear, anxiety, anger, and a host of other emotions as the events unfolded that day and throughout the investigation, culminating in the arrest of Mr. Robinson. These feelings and impressions do not simply resolve because a criminal case has been filed. That's correct, but emotions are not a personal conflict. Okay, prosecutors see things in the course of representing the state and prosecuting some pretty awful crimes that can cause them some significant emotional reactions. This is not unique. This is not unique. Now, I understand they're trying to suggest there's something kind of elevated here because the prosecutor's own whatever blank it was potentially jeopardized by that, potentially in danger because of it. But I'm not necessarily, seeing that they've made that case. Like I guess that's what you want to say. This is different because you're going to have different emotions when somebody that you have a close family relationship with is involved. But if that person doesn't have, formal legal status or, is for any other reason, like specially implicated by this crime, I'm just not sure that this is different than any other case where a prosecution sees some horrifying evidence and it makes them mad and it makes them upset. There is no way to predict at this time what directions this case may take, what critical prosecutorial decisions will be required, and how they may be impacted by the experience Mr. Blank had with his blank, both in real time and after the initial crisis. These influences may be subtle. For example, Mr. Blank may be less inclined to believe a witness whose observations are not consistent with those of his blank. Okay. The prosecutor's belief doesn't matter. The prosecutor's belief is highly irrelevant to the process. It's the jury's belief in the witnesses that matters. So this is not particularly persuasive to me. Prosecutors believe and don't believe different witnesses all the time for all variety of reasons. What this is going to implicate is what they're about to get to here. Do you do something strategic based on that? But then you also have to look at, are you doing something strategic based on that that is improper. It's a bad strategy. It's a distorted strategy because of your personal interest. If your son or daughter, for example, says something happened a certain way and 100 other witnesses said it happened a different way, wouldn't you be probably more inclined in that situation to call the 100 witnesses anyway? I mean, you already don't want to call your son or daughter. I suppose that could create a situation where maybe the defense now wants to call your son or daughter to try to rebut the 100 other people that you've called and you've put on the stand. And then maybe it would materialize. But again, it's got to be something significant. It's got to be something important. So, or he may make specific strategic decisions to avoid his blank having to testify, even if that may not be in the best interest of the state's case. Yeah, these are all possibilities, but we have to look at the likelihood that they're going to materialize. Mr. Blank is empowered by the Utah State Legislature to make commitments for and decisions on behalf of the state. The wielding of the awesome powers of the government against a defendant must be beyond reproach to comport with due process protections. The risk that Mr. Blank's personal involvement may limit his ability to fulfill his obligation to the state of Utah must also be assessed within the context of the grave consequences being sought by the state, the death penalty. Less than 1 week after Mr. Blank's communications with his blank, while blank was at the Turning Point event, were provided to the county attorney and his team, including Mr. Blank, filed notice of the state's intent to seek the death penalty against Mr. Robinson. Such notice is not required to be filed until 60 days after arraignment, which occurs after the preliminary hearing, and yet it was filed concurrently with the charging information. The rush to seek death in this case evidences strong emotional reactions by Mr. Blank and the county attorney, and the entire prosecution team, all of whom were informed of his and Blank's personal experiences. Well, this is one way to color it, isn't it? If we're going to attribute the county attorney's decision to seek the death penalty in a very high profile case, okay, got a lot of public attention because of a very highly situated victim, okay, very prominent, and concerns about political motivations and so forth, needing to maybe discourage political violence. If we want to kind of flip the script on that and attribute to the fact that one attorney had a relative who was there and that emotion influenced the entire office's decision to seek the death penalty, I'm just gonna have to think you're gonna need more evidence of that. We didn't see any evidence of that. The implication here that they sought it early, means that it was an emotional decision or it was a poorly founded decision. That doesn't follow. Okay. It's, I suppose, a possible interpretation of what happened, but it's far from a necessary interpretation of what happened. This case was, front page international news for quite a significant length of time. And people wanted to know, how was this going to be dealt with? Particularly because of the implications, the political implications, that somebody is being targeted for their viewpoints and for expressing, what they think in a public forum. And so people who share those beliefs and those perspectives, or even just frankly the value of being able to say what you think openly in a public forum, without, having somebody shoot you for it, they're going to want to see that this type of behavior is being discouraged. That to me is a perfectly understandable and reasonable justification for why you would seek the death penalty right off the bat in this case. Because people need assurances that, you know, this is not going to be tolerated. You don't have to worry about having a target on your back, because the state is going to, you know, the state is going to vindicate you in the most powerful way it has possible. That seems to me at least as likely, probably more so, than you know, the possibility that they rushed to seek death because one of the attorneys had a family member who was present at the time. The risk here is substantial. Mr. Blank has a concurrent conflict of interest and must be disqualified. So this again, this is conclusory. You know, you need to show me that it's substantial. None of this has really established that. The possibility he might be less inclined to believe a witness, or he might make strategic decisions to avoid having to testify, even if it's not in the best interest of the state's case. You haven't showed me any reason why it would be in the best interest of the state's case for this witness to have to testify. There's nothing in the facts that suggests this witness has anything unique or special to add that couldn't be adequately represented by having any one of the other 3,000 people who were present that day come in and testify about it. So I really haven't seen that that's been demonstrated. Mr. Blank's conflict must be imputed to the entire prosecution office, and the UCAO should be disqualified. When disqualification is appropriate, it is usually sufficient to disqualify the particular attorney with a conflict rather than the entire office, citing back to that Balfour case we just read. However, whether a prosecutor's office should be permitted to remain on a case despite an individual prosecutor's personal conflict is dependent upon the mechanisms utilized to cordon off the potential conflict to prevent the conflict tainting the rest of the office. Now, this is broad. This is quite broad, this description, because it's going to depend on the nature of the prosecutor's personal conflict. Balfour said this specifically in the context of talking about former clients, because those have unique risks of, you know, unique incentives that are implicated when you switch sides in a court case. But that's really not the same thing as, you know, I know one of the witnesses, or, you know, the defendant is my neighbor. You know, these are very different types of situations. So it's not just dependent upon the mechanisms utilized. It really does depend on the nature of the conflict itself. In the matter of State versus McClellan, the Utah Supreme Court found the Utah County Attorney's Office should have been disqualified from the defendant's prosecution. The conflict in McClellan arose from the defendant's former counsel joining the county attorney's office, creating a presumption of shared confidences between former defense counsel and the attorney's office. Yes, former clients are different. The prosecutor's office was afforded the opportunity to rebut this presumption by providing evidence that former defense counsel was properly screened from participation in McClellan's case. Finding there was no evidence of any attempt to screen the attorney from the case, the district court was under an obligation to disqualify the entire Utah County Attorney's Office. Also in the case of State versus Balfour, the Utah Court of Appeals found that where the district attorney with a potential conflict voluntarily recused herself to avoid even an appearance of impropriety, the state rebutted the presumption of prejudice stemming from the pre-existing political relationship between the defendant and the district attorney. That is not what it said. Remember the footnote. They said, we're not going to actually address whether she needed to disqualify herself or not. What they said was that even if there was a presumption of prejudice, the screening mitigated it. So in that case, the conflicted attorney also transferred supervisory authority to another in the office, effectively screening herself from the case. There is no Utah case factually analogous to the circumstances here, the blank being the blank of a witness to a homicide at a crowded event whose traumatic experiences were conveyed to the prosecution in real time and has no unique standing relative to the other 2,900 people who were present, in addition to, Charlie Kirk's staff, Turning Point, university officials, everybody else who was there. However, the same core principles espoused by McClellan should apply. Why? Why should they apply? Why should we apply the rules for having a former client not have their confidentiality jeopardized by their attorney switching sides to the prosecution's office? Why should we apply that same standard to somebody having a relative who's a potential witness? Where blank has a personal conflict of interest, prejudice to Mr. Robinson should be presumed unless the state is able to rebut it. They're not telling me why. They're telling me what they want the outcome to be, but they're not telling me why this is the right outcome. As to the ability of the UCAO to rebut prejudice, so we're already jumping to the assumption that we should presume prejudice. We should assume that the entire office is tainted by this one guy's family relationship. We should assume the entire office is going to have their strategic decisions affected, their personal decisions, so on and so forth, even though they don't share that personal relationship. As to the ability of the UCAO to rebut prejudice, there has already been significant communication between Mr. Blank and the entire prosecutorial team, including the county attorney and potentially others in that office who are not on the team, about his experience and his Blank's experience. Further, it appears that no effort has been made by the UCAO to mitigate the possible prejudice from Mr. Blank's personal conflict, as he remains on and is still the Blank of the prosecution team. The UCAO should be disqualified from prosecuting this case. There's just so much in here that is buried. They've jumped to the conclusion, but they haven't given me the analysis to explain why I should get here. Cases from other jurisdictions are instructive and support this conclusion. In People versus Connor, the California Supreme Court considered the disqualification of a prosecutor's office where a prosecutor was a witness to and a potential victim of defendant's alleged criminal conduct. In upholding the trial court's determination of a conflict, the Connor court notes, because of the dramatic and gripping nature of the circumstances, the pervasiveness of the communications regarding the prosecutor's relationship to the incident, and the difficulty in gauging their cumulative effect, there was substantial evidence supporting the conflict. Okay, so now I'd like to see this case. Can we find this case? People v. Connor. People v. Connor. Let's see. Okay. Oof, that's a terrible format. Let's see if I can find a better one. Give me just a second here. Oops. (666 P2D5). People v. Connor. Okay, here we go. Let's just take a look at these facts, shall we? Make sure I've got the right one. 666 P2D5. There it is. People v. Connor. Deputy District Attorney who was employed in the office was both a witness to and arguably a victim of the criminal conduct. So what are the facts? He was charged with armed robbery. Prosecuted by Deputy District Attorney Broughton. While awaiting the commencement of defendant's trial on the foregoing charges, Broughton was in a courtroom speaking with a judge. At the time, the defendant was in the custody of a deputy sheriff in a nearby jury room. Broughton then heard loud noises emanating from the room where defendant was being held. These were followed by the sound of a bullet hitting the wall. Broughton ran to the jury room and saw the defendant holding a revolver and the deputy sheriff bent over in front of him. It was later established that the deputy had been stabbed and shot. Defendant turned around and, after establishing eye contact with Broughton, swung his arm with the revolver towards Broughton, who immediately turned and ran from the room. As he did so, he heard the sound of a gunshot and saw a bullet hole in the wall approximately 2 feet from where he had been standing. Broughton was uncertain whether that hole was caused by the impact of a previous bullet or by that which had just been fired. Defendant then escaped but was promptly apprehended. He reported the incident to his immediate supervisor, made a written report to the district attorney, subsequently discussed his experience directly with approximately 10 of the 25 deputy felony prosecutors in his office. Some of these conversations occurred in the course of routine office procedures relative to the case. Shortly thereafter, he was interviewed by the news media, during which, in addition to describing the event, Broughton characterized defendant as both a dangerous felon and an escape risk. They reassigned all of the cases against the same defendant to a different DA. He didn't discuss the case with him, but it doesn't seem like he was screened off. He was additionally charged then with assault on a police officer, escape, and escape from prison with force, enhancements of use of a deadly weapon, and inflicting great bodily harm in commission of a felony. He was not charged with any crime for his actions against Broughton, which he could have been, right? It's an assault to point a gun at somebody and to fire the gun. To pull the trigger. That is an assault. That is potentially an attempted murder. Yeah, that's a crime, but he wasn't charged with any of that. Okay, so I wanted to see what the facts were because I wanted to see how close they are to the facts that we're dealing with in this particular case. And they seem not very close because Broughton seems to be the only eyewitness besides the judge to what happened in that situation. He heard it. He went in, he saw it, he personally experienced it. There's no indication that anybody else was in the room. So that makes him a little bit more uniquely situated in terms of being a witness in the particular case. So the information was disclosed to a substantial number of his fellow workers. The size of the felony division was relatively small, supporting the assumption that there is a commendable camaraderie which exists among these officials. The court concluded, while it may be difficult, if not impossible, to prove that a bias of the DA's office will definitely affect the fairness of a trial, the trial court is in a better position than we are to assess the likely effect of the shooting incident. We will not disturb the court's conclusion that the DA's discretionary powers exercised either before or after trial, e.g. plea bargaining or sentencing recommendations, consciously or unconsciously could be adversely affected to a degree rendering it unlikely that the defendant would receive a fair trial. What stands out about this? The deference to the trial court. The judge made that determination and they said, hey, we're gonna go ahead and trust that guy who had the hearings and was in the better position than we are to evaluate what were the potential downsides, what were the potential consequences of this district attorney having been in that position, having shared all of the information. What's likely to happen? You're probably not going to impeach him. He's your colleague. And, he's the witness that it seems like you're depending on to pursue these additional charges. Ultimately, much greater likelihood that that guy is going to end up actually on the witness stand in the case. And ironically, I mean, doesn't it seem like in some ways that's going to be advantageous to the defendant? They already didn't charge him. With very serious crimes that he absolutely could have been charged with based on those facts. If they don't want their prosecutor to be called as a witness, they got a lot of incentive to offer him a good plea deal. So, I get this reasoning. I really do. But it seems to be a little bit off to me. Give me a second here. Okay, I see the sun is blasting my face right now. Hey, whatever little vitamin D I can get, I'm gonna take it, guys. So do pardon me. But let's go ahead and continue. The supervisory nature of Mr. Blank's position with the UCAO also contributes to the need for disqualification of the entire UCAO from the prosecution of this death penalty case. In State versus Tate, the Tennessee Court of Criminal Appeals concluded that the entire District Attorney General's staff should be disqualified from participation in a prosecution due to the Attorney General's conflict, having first appeared as a judge in the case and then becoming employed with that prosecutor's office. Yeah, again, a judge is like a different situation. You're supposed to be completely fair and impartial. And then switching sides and being the one who's prosecuting the guy, it's a bad look. It's a bad look for the system. The Tate court commented that the prosecutor, as the representative of the people in state criminal prosecutions, must always endeavor to promote the public confidence in the integrity and impartiality of the criminal justice system, like not by switching sides. And the prosecutor should be disqualified either based upon an actual conflict or the mere appearance of impropriety. In finding that the disqualification should extend to the entire office, the court noted that there were no screening procedures, the prosecutor maintained the role of supervisor, and there was open discussion of the case amongst him and the other prosecutors. In determining that the appointment of entirely new prosecution team was necessary, the Tate court found the perception of a fair trial is just as important as the reality. The perception of a fair trial is critical in any case and nowhere more than here, where Mr. Robinson's life is in the balance. The rigors of the Eighth Amendment of the United States Constitution and Article 1, Section 9 of the Utah Constitution demand exacting scrutiny on those tasked with enforcing the law. These protections demand the disqualification of the UCAO. Based on the foregoing, the court should find that Mr. Blank has a conflict of interest and must be disqualified. The disqualification should extend to the Utah County Attorney's Office because no effort has been made to shield their prosecution of this case from his conflict. That is the motion to disqualify. That is up next, January 16th. Yes, we will be here watching that. No question about that. As long as the cameras continue to be allowed, which at this point doesn't seem to be any indication that things are changing. Now, of course, today's hearing wasn't in person. It was just restreaming the court's own live feed. So the issues that kind of came up during the last hearing when we were live in court, and the camera person seemed to be just not able to follow the rules of the decorum order, despite being warned that they had to comply strictly to the letter with that order. Don't know yet if that's going to have any potential downstream consequences. But once again, today's hearing continues to me to reaffirm that the judge does take the transparency in this case very seriously. He recognizes the public interest and seems to adopt the perspective that it's important for the integrity of the process for us to be able to see for ourselves as much as we possibly can. And to that end, he's not just accepting, for example, the stipulations of the parties that, oh, this information should be redacted. He rejected some of their requests because he says no, he doesn't think it's justified in his independent judgment. So he seems to prioritize the public access pretty significantly. I don't have any immediate concerns that is necessarily going to change, but of course, we'll have to see how that unfolds. Nevertheless, looking forward to that on the 16th. So we don't have the response yet from the state. Don't know what they're going to have to say. My immediate reaction to it is I don't think they've made a particularly strong basis for disqualification. It's not It's not equivalent to any of the circumstances that are present in the case law that they've cited. He's not, the witness is not essential by really any kind of reasonable interpretation of what the witness actually knows. Not really a good reason, a structural reason like you have with being in a different position in the case as a judge, as a defense attorney, or something like that, that warrants imputing any potential impropriety to the entire office. So I'm not at this point expecting that there's going to be, I don't expect the entire office to be disqualified. I'll say that just based on the motion that's been presented. I could see potentially a situation where the judge perhaps decides to split the baby a little bit, go ahead and disqualify this individual prosecutor based just on the potential conflict, even though, you know, finding a substantial likelihood that that's going to materialize, and that even if it did, it would materially limit the state's ability to prosecute the case, to me seems like a reach. But it's a potential compromise to say we're going to go ahead and disqualify this individual attorney because of the possibility that it could, and then if it did, we'd have, you know, more of a mess that we'd have to deal with at that point in time, and that could implicate other considerations, like Mr. Robinson's right to a speedy trial, for example. If you have to bring on new counsel, you know, change the team. Perhaps then we have to be dealing with, does this conflict get imputed to the entire office? That could be prejudicial potentially in other ways. So go ahead and just address that now by taking this particular attorney off of the case. But I don't see that being imputed to the entire office, because it's just not the same type of situation that you have when you have somebody who was, you know, formerly a defense counsel or formerly a judge or something like that. This is just, you know, this is a fairly distant personal connection with the case. It's a interest that's unique to him. You know, I guess you can kind of stretch it with, well, they're going to want to make him happy because he's a supervisor, but that would just seem to apply in any situation where you're dealing with a prosecutor with any potential conflict, right? They're all collegial. They all got to work together. They all want to get along. There's always going to be something of an incentive to, you know, be a good team member for the people in your office. And so that would sort of require, I mean, it would imply anyway that, you know, you need to be looking at disqualification anytime any individual prosecutor has a conflict of interest. And that, you know, certainly doesn't seem to be the law. So I could see a middle ground here where the individual prosecutor gets disqualified, tell them, screen him off, you know, but the rest of the prosecuting attorney's office is allowed to continue. But we'll see. I will keep an eye out for the state's response. I will also keep an eye out for a redacted transcript by the end of the day. So if you're interested in those things, do keep an eye over there on the Substack, and I will share it with you when I get a chance to do that. So we've got a few comments and new members to welcome. Good Vibes Only 1111. Welcome to the channel. Lucy Fair has gifted a membership. Thank you so much for that. Very much appreciate that. I love pussycats. Yes, I love you. Might this be a silly question, but do all courts allow cameras? Also, why is federal and civil different? Love you, Mom. Hope you and the kittens are doing good. Well, as you can see, the kittens are starting to wake up. And I'm not going to lie, they are at the age where they are starting to drive me insane. They are very active, always getting into things, always curious, wanting to play all the time. And they want to involve me in their business quite a lot. So it makes it sometimes a bit of a challenge to be doing other things that are not cat related. But they are at least very good tempered. So, you know, we have that going for us If I have to feed them to the dog, they don't take it personally. So as to your questions, no, all courts do not allow cameras. Typically in state court, it's up to the court. Some places have rules that don't allow cameras at all. Other places say, like Utah's got this special rule that is kind of unique, where there's a presumption that if somebody wants to bring a camera in the courtroom, they're going to be able to, and you have to have a good reason to not allow the camera in. Other places, they just leave it entirely up to the judge, and the judge can say no for any reason whatsoever, like we saw over there in Delphi, right after they were congratulating themselves on their, big push for more court transparency by allowing cameras in the courtroom at all. It didn't really matter because when it counts, we didn't get to see what happened. Federal courts do not allow cameras at all as a general rule. Now there is a sort of test, a pilot program that's going on in a few very limited district courts where they are allowing cameras in, but it's pretty few and far between. I haven't seen a whole lot materialize out of that yet, but they're essentially like testing the waters, I think, to see if it causes problems, if there's a lot of interest and stuff like that. I certainly support it. I'm with Emily D. Baker on this one after Det be heard. I'm like, we need a camera in every courtroom because you just can't trust the media to tell you correctly what's going on. I've known that for a long time, just from the kind of constant stream of errors, the inability to get things right. When your reporters don't have a legal background, they don't really understand what it is that they're watching or what's important. But Det be heard is what really brought it to the level of actually sometimes the media will just be flat up dishonest about what's happening in the court because it doesn't support the narrative that they want to promote. Why is federal and civil different? So this is going to the motion, right? The motion for intervener status. And it's just because, so civil and criminal cases in general, they operate under different rules of procedure. Most courts will have rules for criminal procedure and separate rules for civil procedure. And it's because they follow different tracks. They have different things that go on. Civil is private. It's private justice between private parties. Criminal justice is public. You got the prosecutor representing the people. So you just can't always translate what happens in one format into another one. The way federal courts do things, they operate under their own rules too, and independent from what the state sets out for different procedures. So it just has to do with kind of jurisdiction, particularly when it comes to procedural issues. Like who gets to be a party and how and stuff like that. It's going to be the rules of the state in particular that are going to govern that. And then if there are specific rules for that type of hearing, you can have different rules for all types of different hearings. You have criminal rules, you have civil rules, you have guardianship rules, you have involuntary commitment rules, you have family court rules, juvenile case rules. You can have all kinds of different setups because all of the different proceedings have different implications. So that's why they are different. Thank you so much for your question. Thank you for your support. Appreciate you being here. Gingerpuff 764. Andrea, thanks for your great analysis as we go through the proceedings in this case. You're my go-to for explanation of the legal proceedings. You're the best. Well, thank you so much for that. I do appreciate it. I spent a lot of time in the trenches doing this kind of thing. And so it's just, I appreciate that I can share some of what I've learned along the way. And also kind of like, just sharing with you guys how I find information. It's a nice thing about the law. I've said many times, you don't have to take anybody's word for it. The law is not something that just exists in somebody's head. The law is a textual process. It is written down. It exists somewhere in a document that is able to be located. And that's by and large what you learn in law school is how to locate the documents that are going to tell you what the specific rules are for the problem that you're dealing with. So, I've had a lot of experience doing that over time, and just find it hopefully helps people kind of understand the process a little bit better to see that in action. Ellen, to U2E, question for Andrea. If D knows P does indeed have a strong case, do you think D could want cameras out to keep public distrust conspiracy theories going in hopes of a rogue jury nullification? This is perfectly plausible to me. If the lack of transparency furthers distrust, which is kind of the presumption, right? If things are open and transparent and everybody can see for themselves, you don't have to just trust anybody, to be giving you the right take on it. You can form your own opinion. If things are happening behind closed doors, then you either trust it or you don't. And we don't have a real good tradition of trusting what our government is doing behind closed doors, probably for very good reasons. This is totally an aside. But I'll just share with you guys one of the things I was reading over the last few days. I got interested in. I was reading the the Church Senate Committee report from I don't even remember when it was. It was from like the 1980s. But it was about there's two separate reports, and one of them is about the CIA's role in Chile in the Allende coup. And the other one was specifically about the CIA's role in various assassination attempts against different public leaders. There was a general in Chile who was assassinated shortly before Allende took office, and it was like basically a predicate for a coup to be able to take place because he was opposed to a coup. He favored a constitutional transition of power. And so the report was kind of about what the CIA knew, when they knew it, who they were helping, how they helped them, and so forth. And it's all rather disturbing. And a big piece of it was how much was happening behind closed doors, and a lot of disputes about who knew what when. No question that stuff was being kept from Congress. More questions about whether stuff was being kept from like the committees that oversee the CIA's activity, Kissinger, the president, stuff like that. There were conflicting stories about who knew what when. But anyway, it's stuff like that completely justifies, in my view, not trusting anything the government tells you about what they're doing behind closed doors. I mean, frankly, even when they come in under oath, like James Clapper did, and tell Congress, oh no, there's no kind of mass surveillance of Americans. And then like literally within a week, we get the Snowden release that shows us all of these different programs for mass collection of Americans' data. So, even if they are, telling us we can't trust them when they're doing it behind closed doors. So, yeah. Lack of transparency furthers distrust, and distrust is favorable to the defense in this case, not just because, I mean, this is certainly part of it, that you get jurors in this pool that, just have their mind seized on, he must have been killed by a lapel bomb or something like that. I can't even keep track, honestly, of what all the different theories are. That's going to be a favorable juror for the defense. So they like the jurors to be suspicious of the narrative. And they also like the environment where more and more theories are being spun that people might it might catch their attention. It might seize their opinion. And they think, I didn't think about that, but that actually makes perfect sense. That's a possible way to interpret this evidence. And the thing is that all of this is happening in the context of very limited public information about the investigation. So, we know very little about what we don't know, and we're probably not going to know more about that until we get to the preliminary hearing in May. I'm very much hoping that the preliminary hearing in May, it's going to be 3 days. I'd love it to be longer. Tell us more. Tell us as much as you possibly can. But 3 days is enough time to provide quite a bit of evidence about why we've chosen Mr. Robinson, why we are asserting that he's the one that did it, why nobody else is being charged with any type of participation, and what they relied on to reach those conclusions. A little just above and beyond what's there in the probable cause affidavit. For example, this is the opportunity to show the evidence, not just describe it. So the text messages that are the source of a lot of controversy and questioning, these text messages between Tyler Robinson and Lance Twiggs. Yes, show us the cell phone extraction, or show us the screenshots from the phone. Show us whatever it is that you have that you preserve these text messages in, so that they could be transcribed verbatim, and then we can evaluate the strength of that evidence. And we can also evaluate how the defense responds to it. Okay, if there's a cell phone extraction that comes into evidence and we get those text messages out of that cell phone extraction, if we don't have a defense expert on cell phones testifying to tell us there's a problem with this extraction, or there's an issue with the authenticity of these messages or something like that, then we can infer from that, that they don't have that evidence. There isn't a problem. So it's going to hopefully maybe settle a little bit of this environment by making it clear how much we sitting here right now don't know. We think we do. There's like this attitude that we already know everything that's happened, and we know what the evidence is, and we know how the investigation transpired and stuff, but we don't know anything. Okay. And there's going to be a lot that comes out in 3 days that has the potential to, hopefully just make that a little bit more clear. So yeah, I think for all of these reasons, it's in the defense interest to have the proceeding closed, because illusions are not getting dispelled. Okay. Questions that people have about, why do people think this? Why is the evidence asserted to be that? They're not being answered. Okay. It's promoting just a general suspicion about the prosecution's case. And it's producing all of these theories, all of these different ways of trying to interpret what is known. And that is helpful both in terms of the effect that it can have on the jury, but also because it's basically focus grouping for the defense. It's focus grouping potential issues, that they can evaluate in light of the evidence that they have from the discovery, and see, is this a question? Is this a hole I could maybe poke in the case? It seems to resonate on Reddit. Is that something that a jury pool might be willing to get? So yeah, I think very insightful observation here. I think it's very much the case that that could very well be part of the reason why the defense is pushing for the lack of transparency, because they're benefiting from it. Brooke JF started watching Delphi. Because of that, I attended a local case with cameras removed. Turned out to be a great judge, great defense team, fair trial with a guilty dude, but I'm glad I saw it for myself. Brooke, that is awesome that you did that. I am so glad that you did that. I encourage people all the time, go down to your local court and just watch it and see what's happening. Yeah, you can watch a trial, but there's so much that goes on that isn't trial. Just the volume of the day-to-day criminal docket. It's good to see how those things are handled, how the people behave, what the relationships look like, how are things getting resolved. There's just so much that you can learn about your community by watching its court and seeing, like, Here's how the cops testify. Here's how they interact with the defense lawyers. Here's how the judge treats people. It really does tell you a lot about the quality of the justice that you're getting in your particular community. So I'm glad that you saw that, because there's something of a tendency, I mean, in LawTube certainly, but just in there's always selection bias in terms of what gets coverage, what doesn't, what gets cameras in and what doesn't. And so it can kind of distort your perspective on, what's happening in like all the other cases that aren't being televised, that we aren't hearing about. And it can distort your perspective on, just the process itself. Is it generally fair? The participants involved, are they trying to do a good job? And so, because I spent a lot of years in this system, and it's definitely got its flaws, but most of the time it works reasonably well. I very firmly believe that. Most of the time it works pretty reasonably well. You're almost never dealing with situations of, hey, this person is completely innocent and did nothing wrong and just got caught up, or, police framed them or something like that. It does happen, but it's a very small minority. Most of the time what you're dealing with is, this person did something bad and they got caught red-handed and there's a lot of evidence against them, and we are litigating around the edges. We are litigating what is the appropriate charge. We're litigating what is the appropriate outcome. And that's how the system is functioning. So most of the time we are getting the right people, and we're just we're serving to make sure that what is actually being carried out as a result of that is fair and proper and the way that we think it should be done. Delphi. Delphi was such an outlier. It's such an outlier. And so in many ways, I'm glad that people did care about that and did follow it, because it's just like it's jaw-dropping how horrifying what happened in that case was. But it is also important, I think, to keep that in perspective, that just because Delphi was absolutely wild in terms of, all of it, the framing, the lying by the investigators, the hiding all of the evidence that's favorable to the defense, the judge who is just dripping with contempt for the defense team. All of that is so far beyond the norm of what you normally see in a criminal case, that if like that was all you had really followed, you're going to have a real distorted view of the system. So very glad you did that, Brooke. Because it is helpful, I think, to just maintain perspective and help us, remember that all of these things are not equal. We do see the ones that we see high profile for a reason, but there are thousands, if not hundreds of thousands, that are flying underneath the radar every single day. And they're really just as important as the ones that get all the attention. Well, guys, appreciate you joining me here this morning. What do we have going on? So as far as what's coming up, what to expect from me, I do have some things in the hopper that will be coming out in the next few days. I've got some more of the Jim Martin trial, of course, continuing to watch that. I have my video that I have been promising, the LawTube for Lawyers look at Luigi Mangione's motion to suppress and the whole choice of law issue, what that is, why it's going to be dispositive, and how that plays into my prediction that this is, it's hard to bet against. It's hard to bet against a motion to suppress being denied because that's such a strong default. But they're in a good position. I just got to say it. They're in a very good position. It's hard to bet that that's going to happen because it's always the unlikely outcome. But they're in about as good a position as you want to be in, factually and legally, to support the motion to suppress. So have that in the hopper as well. I am looking at the Sarah Grace Patrick trial that is scheduled to start on January 6th, I believe. Now, there's still a possibility that it's going to be continued because they're still waiting for, I guess, some reports and stuff like that. So I'm keeping an eye on it, but it is at least right now currently scheduled to start on January 6th. So I will plan to watch that one if it does start when we're expecting it to. This is not really sure yet kind of what the evidentiary basis is for the charge, because there's not a whole lot that's known about it. But this is a 17-year-old girl who was at home with her 5-year-old sister and her mother and her stepfather. Her mother and her stepfather are shot dead in their beds, and Sarah Grace, 17-year-old, calls 911. So there's an investigation of the parents' murder, and then in the meantime, Sarah Grace is apparently contacting these like large YouTube TikTok accounts, and suggesting that they should cover her parents' case. It'll be big. She can give them inside information and stuff like that. And then within a couple of weeks of making these contacts, she ends up being arrested for the murder of her mother and her stepfather. So the prosecution has said they have a mountain of evidence, but that, of course, is a characterization. That is not a fact from which I can form my own opinion about whether this is a mountain of evidence or not. So we don't really know the specifics of what they have. Is this, based on internet searches? Did she talk to people? Are there cameras in the house? Like, just a lot of things like that we don't know. So I'm interested in, finding out what is this mountain of evidence and so forth. So keeping an eye out for that. What else? I showed you last time, I got that whole stack of records in the Rex Heuermann, the Long Island serial killer, allegedly, case. So there is a whole lot there potentially to go over. The reason I got it in the first place is because there was a Fry hearing, motion to basically evaluate whether they were going to be able to use this novel whole genome sequencing DNA technique that they've used. So I've been reading through that and honestly trying to digest it, because it's scientifically a bit technical. I've been able to get my mind wrapped around the conventional STR type of DNA analysis that has been done in criminal cases for many decades. But this is a whole new universe. And so just kind of trying to make sense of how does this even work, and like what exactly is this testing even doing and stuff is a little bit, it's just a little bit more of a challenge that I want to get oriented in. But that one, I will undoubtedly have some stuff to say about as well. Continuing to follow the Nick Reiner and see what happens there. That one, of course, also has a hearing coming up for the arraignment and entry of plea. I am predicting a not guilty by reason of insanity plea, but I don't know if that'll happen at the outset or potentially down the road, or maybe it won't. But that's my prediction on it. So that's kind of the stack of stuff I got on my pile right now. Other than, of course, continuing to monitor Tyler Robinson, seeing when we get the response from the state to the motion to disqualify, and then also keeping an eye out for the defense motions that have been hinted at, both to remove the cameras from the courtroom and also to expand the gag order. Remember, they want to gag Pam Bondi and the AG. They haven't said that specifically. That's just me. That's just me kind of assuming that's what they mean when they say we need to gag politicians and other people like that. They want to shut up the Utah governor. I don't know, but I have some concerns about that from a just legal viability kind of standpoint. So keeping an eye out for that one as well. A lot going on right now as we get into the new year, guys. So as always, feel free to check in on Substack. I do a lot of stuff over there if I don't necessarily want to, put my makeup on and get the lights going and stuff like that, and coordinate with my husband to do a live stream or whatever. So a lot of times I'll just I'll do stuff in writing over there on Substack if that's the kind of thing you're interested in. Otherwise, hey, you know what to do. You guys know how to use YouTube. I don't need to tell you, all the things. So if you're interested in more, you know what to do to find it when it comes up. So with that, guys, hey, appreciate all of you. Appreciate you being here. Appreciate you enjoying the Zen, that just Zen calming feeling that I get every time from Judge Graf's courtroom. I do. I find it so calming. It's such a unique demeanor in a judge. In my experience, I don't find many like this. It's like ASMR court. It's you just kind of doze off a little bit. You left feeling that everything is okay. Maybe that's just me, but particularly enjoy it. I'm going to get outside and maybe enjoy some of the sunshine. We're at the end of our yard cleanup kind of season here. Almost at the end of December. We're still getting like calendula flowers out in our garden. This has been kind of a unseasonably warm winter for us up here. Don't think we got a whole lot of snow over here on our side of the mountains yet. So there's no snowboarding yet, no skiing yet, nothing like that. Probably have some in the Cascades. I haven't really checked, but so finding other ways to get our vitamin D in and move that old biological soup around in its little meat sack. Get things operating at their optimal level. So with that, guys, I'm going to be checking out for the day. Do take some time for yourselves today. Enjoy your embodiment. Find things that get you out of your mind. It's I think that the challenge that I personally encounter quite a bit in the winter is because it's not always that pleasant to be outside. So it's easy to just kind of turtle up inside, scroll the feeds, read the things. And there's definitely some benefit to that, but just make sure it's serving your interests, that you're feeding your mind, but you're not forgetting to live out there in the world as well. Because there are people out here that matter, people that care about you, people that want to see you, people that want to interact with you. Things to do and things to enjoy beyond just the pleasantness of having an occupied and not bored mind. So hope you get some of that. Hope you all have a wonderful new year. If I don't see you before then, and I probably won't, I'm not planning on going live before then. So have a wonderful new year. Make sure that your animals are prepared. We have dogs that do not like fireworks, and we have neighbors that like to shoot them off at every opportunity. So, do what you can to look out for your animals and make sure that they feel safe and secure as well. With that, guys, enjoyed having you all here. Thank you all so much for your support. Thank you to the mods for everything that they do, keeping the chat a great place to converse, to share your ideas, to say what you think, and people can agree or not agree. And as long as you're not an asshole, we're pretty cool with that. So enjoy the free speech zone that we have here, guys. And hey, we'll be back. So until next time, appreciate all of you. Thank you for being here. And we'll see you then. And have a happy new year.